can't sue, public officials. Why, gosh, if we were to allow them to be sued, they would be afraid to make decisions. And every time they made a decision, they'd be sitting there, oh, I can't make this decision because somebody might sue me. And the court goes on to answer that question. The inhibiting effect is significantly reduced, if not eliminated, however, says the court, when the threat of personal liability is removed. First, as an empirical matter, it is questionable whether the hazard of municipal loss will deter a public officer from the conscientious exercise of his duties. City officials routinely make decisions that either require a large expenditure of municipal funds or involve a substantial risk of depleting the public fisc. More important, though, is the realization that consideration of the municipality's liability for constitutional violations is quite properly the concern of its elected or appointed officials. Indeed, a decision-maker would be derelict in his duties if at some point he did not consider whether his decision comports with constitutional mandates. Boy, there's a word that ought to be underlined. That comports with constitutional mandates, and did not weigh the risk that a violation might result in an award of damages from the public treasury. My position then is, right along with the Supreme Court of the United States, that when the mayor of my city makes a decision, he damn well better be looking and thinking about George Gordon when he makes that decision. When a policeman stops me out here and wants to ask me why I don't have a license plate on my card, it better be in his mind, am I violating Mr. Gordon's rights? Because if it isn't, I'll damn well remind him of it. I'll remind him of it right here. And that's where you're going to have to remind him, because after all, when they violate your rights, that's the guy in the parking lot backing into the side of your car. And if he can back into the side of your car and you can't get his license number, the color of the car, the make of the car, the identification of the driver, your rights have been violated, but you'll never get a recovery, and he'll just continue on and on and on doing that. He'll do it to everybody that he comes in contact with because nobody's ever called him to account. Public officials in this country, since the abolition of our grand jury system in the last 25 or 30 years, have not been brought to account. Where there are no grand juries working, there is no public accountability. You can't put the fox at the door of the hen house and expect accountability by the fox. Who's he going to account to? The hens? That's what we have in Idaho. So I'm not going to sit here and read this entire case to you. I'm just reading some of these key sections out of Owens versus City of Independence. The next case that comes, and I want you to take a look at this case because I plagiarized these from Walt Mann, and Walt, I want you to forgive me for plagiarizing your two cases here. I'm not going to pay anything for them, but then you can't sue me because these are public documents. But I want to give credit where credit is due, and Walt Mann has written a fine series of books pursuant to administrative law and procedure. And I recommend these books to everybody that I come in contact with, and I don't think you'll get too mad and sue me. Walt, if you want to sue me, you're wasting your time because I'm a deadbeat. So you can forget that. But we learned about a case called Maine versus Thibauteau. That's a case that's kind of a companion case to this City of Owens versus City of Independence, in that it talks about Title 42 U.S.C. 1983. I'm looking at the syllabus here, and I'm going to read to you a few sections. It talks about the jurisdiction of Title 42. Now, let's read a little bit in here, and I'm going to give you both of these cases because these two cases taken together with all of the citations that come out of them will just take all the wind right out of the sails of your government officials when they sit there preaching to you about sovereign immunity. When somebody mentions to me the word sovereign immunity, I just look at them, with pity. Because the issue was settled in 1835. There never was any sovereign immunity for corporations or for municipalities, that is, city and county governments. Never has been. That's just a myth that's perpetrated by the legal profession against ignorant citizens when they say, well, you've got to have the permission of the government in order to sue them. Poppycock. I remember when I was a little kid, 10 years old, well, you've got to get the government's permission to sue them. I'm not a corporation. I come under the Hale versus Hinkle doctrine. I'm an individual, and my right to contract is inalienable, and my right to act is inalienable. And when you trample on my rights, mister, you got a problem in your life. And you'll have that problem with me for the next 3 years, every time you do it. And when we get 50 or 75 citizens operating in the courtrooms, not thousands, not millions, I don't need, gigantic organizations, just a few good hands that are willing to go to jail, that are willing to take the knocks and the bumps and the bruises, and will not make bricks for those Egyptians. And that'll straighten our taskmasters out. And for the rest of you people out there, life will be a lot more pleasant. Let's read a little of the syllabus here in this Maine versus Thibauteau as we close out this lesson 27. This case was held by the Supreme Court. Title 42, U.S.C. 1983, which provides that anyone who, under color of state statute, regulation, or custom, deprives another of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the injured party, encompasses claims based on purely statutory violations of federal law, such as the respondent's state court claim, state court now, that petitioners had deprived them of welfare benefits to which they were entitled under the Federal Social Security Act. Given that Congress attached no modifiers to the phrase and laws, the plain language of the statute embraces the respondent's claim, and even were the language ambiguous, this Court's earlier decisions, including cases involving Social Security Act claims, explicitly or implicitly suggest that 1983 remedy broadly encompasses violations of federal statutory as well as constitutional law. How do you like that? It isn't just a matter of these public officials or these municipal corporations violating your constitutional rights. If they violate statutory provisions, they're liable for damages under 1983. How's that? We've got policemen here that arrest you and take you to jail in violation of Idaho Code 49-1109, 10, 11, 12, 13, 14, and 15, who will not take you directly to a magistrate in spite of the fact that the statute is clear and unambiguous on that subject. Now, that doesn't mean that I'm going to sue the policeman every time he does that, because that's really not a very serious violation of my rights. It's not difficult in Ada County, Idaho, to get a policeman to violate your rights to the extent of locking you up in jail for several days in solitary confinement without toilet paper or soap. For crying out loud. I don't need to go after them over some picayunish statute. These guys in Idaho act like that they're Marine Corps recruit or boot camp sergeants. That's the way they treat citizens here. It isn't difficult to get these guys to violate your rights. They do that about as easily as falling off of a greased banana peel on a log in the Colorado Rapids. Anyway, this Maine versus Thibauteau, I want to make sure that we send that out in this lesson so that you have both of them. All right, now let's recapitulate a little bit pursuant to what we're going to do in offensive law. The difference between offensive law and defensive law is simply that you're going to change chairs. You were sitting in the defendant's chair, now you're going to sit over here in the plaintiff's chair. Now that you're sitting in the plaintiff's chair, you've got to prove your prima facie case. Just picture it as a traffic court case, and instead of you being the defendant, you're now the prosecutor. You've got to lay out every material fact in the prima facie case, and you've got to prove each and every one of those. And your opponent is sitting over there now watching you. And he's watching, oh, he forgot to prove this. Oh, Gordon forgot to prove that. He forgot to prove this. And as soon as you finish your case, he'll jump up and say, Your Honor, I move for a dismissal because Mr. Gordon failed to prove his prima facie case. Motion time, dismiss the jury. In other words, they're going to do to you just exactly what we've just trained you to do to them. So in order for you to prevent that, you're going to have to dot every I and cross every T during every phase of this case. That's why it's so crucial now that you go back to your initial training at lesson 1, 2, 3, and 4. When you're in jail, Officer, what's your name? Are you married? Get all the information you can. When you're in the jail cell, you ask a fellow prisoner, what's your name, address, and phone number, etc. If you don't have a pen and paper and you're put into a cell where there's other people remembering lesson 4, they've got pen and paper. I paid a guy $10. I gave him a promissory note. I said, sir, if you'll give me that pen and 2 sheets of paper, when I get out of here, I will bring you a $10 bill and put it on your account. I needed 2 pieces of paper, but let me tell you, those 2 pieces of paper bought me a lot of names. I've got the names of every one of those sheriff's deputies with that $10. They're right here, and you're going to get it and you can read them. Roy Jones, Lord Wellman, got them all. See? These are the people that I named in the suit because they're the people that I used when I was in jail. I didn't know who those people were, but I got their names because they were the people that perpetrated the acts. What acts did they do? I wrote them down. Well, what did this guy do? You know, a year and a half later, if you were to point out and say, what's that guy's name? I don't know, but I remember seeing him one time, but I don't remember where. But that isn't the case with me. You see, I've got file folders sitting over here. The mechanics of the case, remember. Officer Smedley did what to me? Here's what Officer Smedley did. Here's the time, the date, and the place that he did it, and here's the 3 prisoners who were in the cell that witnessed it. Or here's the officer that saw it done. So that when I go into court, I've got all of my bases covered. And I'll probably forget a lot of them. But remember, you've got to have direction. You've got to have action. You've got to be directed to do this. These offensive actions are not accidental. You will never succeed in an offensive action accidentally. Every stage of it has got to be carefully drawn out and laid out and carefully prosecuted and demonstrated in front of the jury, each and every time. All right. Notices. I had to file this case on all 20 of these defendants. I had to go to the rules to find out that the Attorney General gets 2 copies of this. Every one of these people have been notified and have answered, and now we're down to 5 law firms defending them. But I had to have my notices down. Affidavits. If you'll notice in this case, there are a number of affidavits. Take a look at the strategic location of the affidavits in the sworn testimony as to my conduct at all times. Because there are times when you need to get sworn testimony and affidavits from others or to get it documented. Because a case like this isn't going to go to trial for a year, maybe 2 years. 2 years from now, 3 or 4 very key witnesses could have died from heart attacks or moved to Miami, Florida. Those affidavits from those persons will suffice in a pinch as the essential testimony. It's imperative that you get all of your information and your case down and down pat and in writing as rapidly as possible. In this case, I didn't need any restraining orders because they're not threatening to do anything to me. But a restraining order can only be filed after an action. So let me show you how the mechanics of a restraining order would come down. You get a notice that in 10 days the boss is going to take $500 from you. Okay? You can file an action and get a restraining order to prevent that. And you can do that pursuant to a case called Snyadek. And so now you're going to need this Snyadek case. Let me write that down. There's a threat. All right, so Snyadek versus Family Finance Corporation, which is an administrative seizure, decided in 1969, and it's 395 U.S. 337. Let's take a look on page 337 and just start off, and let's run through this Snyadek case because the background of this one is exactly the case that you need when you're dealing with the W-4, your employer, and the IRS. This is the case in point, or the case in chief, as they call it. Starting at the top of the syllabus, it says, under Wisconsin's garnishment procedure, the clerk of the court issues a summons at the request of the creditor's lawyer. And the latter, by serving the garnishee, here the employer, sets in motion the machinery whereby wages and here 1/2 those due the employee are frozen. The creditor has 10 days in which to serve the summons and complaint on the debtor after service on the garnishee, although here the petitioner was served the same day as the employer. The wages may be unfrozen if the wage earner wins on the merits in the suit on the debt. The petitioner moved that the garnishment proceedings be dismissed for failure to meet the 14th Amendment's procedural due process requirements, but the Wisconsin courts approved the procedure. Wisconsin's prejudgment garnishment of wages procedure, with its obvious taking of property without notice and prior hearing, violates the fundamental principles of procedural due process. Now here's what the IRS does to you, isn't it? Don't they send you a letter and tell you in 10 days they're going to do something? In other words, the IRS is using the exact unconstitutional procedure that was declared unconstitutional in 1969 in Wisconsin. But they just go ahead and keep doing it because unless somebody stops them, there isn't any reason for them to stop doing it. Now let's take a look at the case. Did you notice down here at the bottom of the page I underlined, Mr. Justice Douglas delivered the opinion of the court, to which I say, God bless Douglas. Respondent, says Mr. Douglas, initiated a garnishment action against the petitioner as the defendant and Miller Harris Instrument Company, her employer, is garnishee. The complaint alleged a claim of $420 on a promissory note. Well, I would guesstimate she probably owed the money. And this outfit probably wanted to collect it. Now the question is this woman entitled to procedural due process by the law of the land under Hale versus Henkel? The garnishee filed its answer stating that it had wages of $63.18 under its control, that's her boss, earned by the petitioner and unpaid, and that it would pay 1/2 to the petitioner as a subsistence allowance and hold the other half subject to the order of the court. Petitioner moved that the garnishment proceedings be dismissed for failure to satisfy the due process requirements of the 14th Amendment. The Wisconsin Supreme Court sustained the lower court in approving the procedure. And the Wisconsin statute, going on then, gives a plaintiff 10 days in which to serve the summons and complaint on the defendant after service on the garnishee. In this case, the petitioner was served the same day as the garnishee. She nonetheless claims that the Wisconsin garnishment procedure violates that due process required by the 14th Amendment, in that notice and opportunity to be heard are not given before the in rem seizure of the wages. So here's an in rem seizure. An in rem seizure is always a common law seizure. Well, it doesn't have to always be common law because it can be property on the high seas. But in this case, we're talking about an in rem seizure, which is a common law seizure. And they can do that. What happens in Wisconsin is that the clerk of the court issues the summons at the request of the creditor's lawyer, and it is the latter who, by serving the garnishee, sets in motion the machinery whereby the wages are frozen. That may, it is true, be unfrozen, or they may, rather, it is true, be unfrozen if the trial of the main suit is ever had and the wage earner wins on the merits. Well, wait a minute. If you just come in and take this guy's property, he has to sue to get it back, doesn't he? So the wage earner has to take the issue to court and become the plaintiff, doesn't he? What a clever renvoy. Isn't that what the IRS does to a taxpayer? They tell you, we're going to take your property, and if you don't like it, you can appeal to the tax court, so that now you can stay in the good old mercantile civil law, that you can never get your action at common law. So this taking of the property in rem is a common law action, but they're going to do it in maritime civil law, aren't they? And make you come back and sue and prove that you don't owe the $420. But in the interim, the wage earner is deprived of his enjoyment of earned wages without any opportunity to be heard and to tender any defense he may have, whether it be fraud or otherwise. So there he's denied an opportunity to be heard. The action is taken, his property is taken. All right, now going down, you'll notice it's underlined. Let's take a look at the next underlining. The question isn't whether the Wisconsin law is a wise or an unwise law. Our concern is not what philosophy Wisconsin should or should not embrace. We do not sit as a super legislative body. Now here everybody says that the Supreme Court is just that, but here's Douglas saying we're not sitting here for that reason. In this case, the sole question is whether there has been a taking of property without that procedural due process that is required by the 14th Amendment. Now, isn't that what happens each and every time the IRS makes a claim upon your wages and salaries and your employer steals it from you? It's a garnishment in exactly the same way as this unconstitutional Wisconsin procedure in 1969. So here's your good old employer, along with the IRS, practicing a forbidden practice that's already been ruled against. And who's going to bring the issue to the fore? Well, you are, in an offensive action. You're the one that's going to bring it forward. On page 340, in the context of this case, the question is whether the interim freezing of the wages without a chance to be heard violates procedural due process. Well, it wouldn't violate procedural due process if there's a contract, if there is some privilege that you're exercising. If you're a corporation, they can just take your bank account. There's no problem with that. I understand that. But when you're a sovereign citizen and a natural person under the Hale Doctrine, you've got to have procedural due process. Going on, the fact that a procedure would pass muster under a feudal regime, note the words feudal regime. Did Douglas understand feudalism and feudal law and common law? He used the very words. Yeah, maybe it would work in a feudal regime, does not mean it gives necessary protection to all property in its modern forms. We deal here with wages. Well, isn't that what you people deal with? Wages? Are we talking about wages under your W-4? A specialized type of property? Are wages property then? Presenting distinct problems in our economic system. And we turn then to the nature of that property and problems of procedural due process. Oh, while I'm looking at it here, have you ever heard of people threatening to fire other people if their wages are garnished? Maybe your employer, well, if your wages are garnished 2 times, that's grounds for dismissal. Have you ever heard that? Take a look at these lines. Until a recent act of Congress, number 304, of which forbids discharge of employees on the ground that their wages have been garnished. Garnishment often meant a loss of a job. Gosh, that happened in 1969. You know, I've heard of people being dismissed as recently as 2 or 3 years ago because their wages were garnished. I think a guy'd have a cause of action right here under SNIADEC. I think all you need is SNIADEC, a complaint, a summons, and I think you're ready to take judgment. If your wages are, if you're ever fired or you're ever admonished or in any way disciplined because of a garnishment, that's a cause of action under SNIADEC. Don't forget that. And then he went on to say the idea of wage garnishment in advance of judgment of trustee process of wage attachment or whatever it is called is a most inhuman doctrine. It compels the wage earner trying to keep his family together to be driven below the poverty level. Now, this entire SNIADEC case is only about 10 pages long. Now let's think about it for a moment insofar as the mechanics are concerned. Owens versus City of Independence and Thibauteau are Title 42 cases if you've got a civil rights violation. But what happens if you just have a simple stealing or a theft of your property? You don't need to go to the federal district court. It doesn't take a long-winded, knock-down, drag-out brawl for 3 years to get redress of grievance, as in the SNIADEC case. This lady must have worked 2 or 3 years in order to get this case all the way to the Supreme Court. You're not going to have to do that because the issue is already settled. Wages are property. And wages, if there's going to be a seizure, it's an in rem seizure. If it's an in rem seizure, that's a property seizure, it has to have a judicial order. You've got to have procedural due process. And that means even if it's an administrative hearing, there's got to be some form of administrative process that can be appealed from. And you don't get that with the W-4 employee IRS caper with these $500 fines. Now, I don't know of anybody who's been successful yet, but I don't know of anybody that's taken them on this particular vein. But here again, remember, if you lose, you're going to have to pay the court costs, and the average blue-collar worker working in a factory somewhere is no more competent to go into court and argue a position or a case than he would be to fly. And that's where it's up to each and every one of us, if we're going to be competent pro se litigants, to educate ourselves and get ourselves to a point and a place where we can go into the courtroom and argue this position successfully. Now, I want you to notice the SNIDEC has about 10 other citations. You can shepherdize those 10 other citations and put those together, and you can put a case against the IRS outside of Title 42. Just a simple conversion of property, which is a common law trover action in which you want the return of your property. And in a trover, there is no provision now for punitive damages, only the property itself that's been unlawfully converted. It's a simple, straightforward action. You can have that one determined in probably 6 months to a year. And you may even get your employer, once you've shown him your case and his attorney has seen it, to sit there and say, wait a minute, we're not going to do this anymore. Now, we're trying one case in the federal district court with a locomotive engineer from Pocatello, Idaho, and we're going to use the SNIDEC case, and we're going to use the federal district court to do it. And if the federal district court fails, which we have a sneaking hunch it's probably going to fail, then we're going to take them into the district court, and we're going to sue the employer, which in this case happens to be the Union Pacific Railroad. So I would say that 6 months to a year from now, we'll know a whole lot more than we do today about how to handle or how to defend ourselves and how to take, well, I think that the best defense is a better offense. And I think an offensive action here under a trover against your employer will do a tremendous amount of good. But as I say, I don't know of too many people that have done this. None as of this moment in time. But we have one case underway that we think we're going to lose because we made this error. We named the IRS as the party. And now, after careful research, we're already locked in because the IRS is the party that's been named in the action. Well, we won't make that mistake again. And I expect on July the 11th that the judge is going to tell us of our error. But we can always recover from the error because our cause of action, and if it's not against the IRS, is against somebody else. And it's the UP Railroad in this particular case. So there's the SNIDEC case. And here's Owens versus City of Independence, Thiebateau versus Maine. Those cases will be coming to you here in Lesson 27. Lesson 27, when we went over it and we took a look at the nomenclature that we've covered, we noticed that we have notices. That's your case in chief. Here's the notice that went out to all 20 of the people involved. Affidavits. If you'll notice that we have affidavits in here to take testimony and to make sworn statements of key facts and issues throughout the entire procedure. From the day that we were in the jail, you'll notice that I filed affidavits. From the day that we were in court, I filed affidavits. And I filed those affidavits, and they're now part of the case. The restraining order I didn't use in this particular case because it isn't needed or necessary. But when you're talking about your W-4 form, you'll need a restraining order. A restraining order is simply a motion to restrain someone from doing something that's going to harm you after you've filed a cause of action. You have to have a cause of action, and you must have filed that action with a court. And then you've got to motion up a show cause hearing, and then bring your employer or bring whoever it is that's threatening to take your property from you, bring them into court and force them to show cause as to why they should not be restrained from taking any further taxes or from taking any further of these fines. Now, the interpleader with your boss, may save your job. And if you're unemployed for 2 or 3 years while you're going through litigation, and remember that this police chief was fired from his job. I don't know how much money he got from this, but I'm sure that it was as much as or more than he was going to earn during that period of time, plus some punitive damages. But during the 3 or 4 years that this case was in litigation, he probably had a hard time making a living, and you may have that same problem. So you better count the cost before you do this. Can you afford to lose your job? And if you can't, why don't you go to your boss first and talk to him about an interpleader and say, boss, I know you don't want to get involved in this. Why don't you stop stealing my money? Why don't you file this interpleader with the IRS and see if they won't bug off? It may be that the interpleader will solve the problem. Now, under Title 42, remember, is a civil action. Under Title 18, Section 241, is the criminal section that covers the same thing as a civil rights violation under the civil action, and that is that it's a criminal matter. If a person violates your rights and it's done so with intent, maliciousness, if a statute is violated, then you may have grounds for a criminal violation, and you ought to write a criminal complaint and take it to a federal grand jury. You have a right to do that. Take it to the prosecutor. And always go with a couple of 3 witnesses when you go to your county prosecutor and say, I've got a sworn complaint here for Officer Snodgrass. Officer Snodgrass did the following acts in violation of my rights and in violation of these statutes. And these witnesses are here. My affidavit is complete, and I want to file charges against Officer Snodgrass. They'll either will or they won't. But that's another subject. The criminal portion of your action, your offensive action, is a sideline. It won't gain you anything. The government may prosecute a person or they may not. Our experience so far has been absolutely nil. They absolutely will not prosecute their own people. You cannot get the Ada County prosecutor to prosecute any other public official. At least that's been our experience, and we've tried it several times. That doesn't mean that we're not going to succeed, because before we're finished, we're going to have our grand juries working in Ada County, Idaho. And when the grand jury is working, we'll prosecute these people ourselves. But in the meantime, you can bring the action and then file the affidavit and the information in your case. And that will make it a factual matter that you can then take to the jury to show the seriousness and the intent that you had to seek redress of grievance. Now let me point out the last item. We just talked a few lessons ago about jury instructions. Remember that jury instructions in a case of this size will probably amount to 50 or 75 jury instructions. And don't you ever think that I'm not going to have Owens versus City of Independence and the Thibodeau case and the Snyadek case in my jury instructions when I send this to the jury. And that's why when I get these officers on the witness stand, I'm going to be asking them questions based upon Owens versus City of Independence. I'm going to take quotations and citations, and I'll say, I'll fashion my question to Officer Snodgrass in such a way that when he answers no, I'll put that section into the jury and let them see that, as a matter of fact, the Supreme Court says there is no such thing as sovereign immunity. When he says, well, I have immunity because I'm a police officer, and do you believe that police officers have immunity from prosecution? Oh, you bet. And do you believe that a police officer, when he violates the rights of a citizen, can avoid prosecution? Well, yes. And then we'll cite a couple of these sections that I just read to you a little while ago in a jury instruction and demand that the jury see the laws that come from the Supreme Court. You see how that works? I'll never be able to sit there and say, well, ladies and gentlemen of the jury, in Owens versus City of Independence, the Supreme Court has said this and such. Well, I'll be shot down in a heartbeat. But when we get Officer Snodgrass to make the factual statements, and when I take the stand and I make the factual statements, pursuant to Owens, Thibodeau, Snyadek, and a dozen other cases, that's what will put my case and my issue right into that jury room so that the jury can see the Supreme Court of the United States and its determination and its decisions. Well, that'll cover Lesson 27. I wish you a lot of luck, and I hope you get out there and tune those government officials up, because it's Lesson 27 and the offensive actions that's going to bring the government down to your side.